right, I'm going to get a quick attendance. This is really not a mandatory thing, so it's not a big deal, but I'm going to do it anyway. Okay, John is here. Maida? Hello there. John Bautista. John Bautista. Natalie Burford. Hi, Burford. Alex. Diana Cervantes.
She's coming.
Okay. Elena.
Here.
Brittany Frazier. Huh. All right, no Brittany. Jack Golden. Okay. Destiny. Here. Dina Casilla.
This one.
Sorry, I keep making that mistake.
Two.
Andrew is here. Torrin Langley. Well, Torrin is the one who's got the note taker, correct? Okay, very well. Okay, Grace Nagy. Grace Nagy. Shania? Okay. Kate. Sarah is here. Koos. Velasco is here. Sean Walsh. Josh is here. Drayton is here. Greg. Rawls. Alexa. O'Daniel. Very good. Cam Perez. Good luck. Dior. Corinne. Ahmed. Will Fogler. Okay, and you are, we already said you'd be here though, so I didn't mark the absent. Okay, all right, great. All right, the senator is all I know. All right, good. Okay, let's get to the order of business at hand here, and what I want to do is go over with you basically what you're going to need to know to be successful on this exam. And let me say this, that's what we're shooting for. So if you have questions, please stop me and we'll attempt to answer them. At the same time, I really do want to get through all of the material, and it's probably going to take us, you know, a substantial amount of the time to get through the material to tell you what you need to know. So with that said, I'm going to do this kind of, I guess, chronologically. We're going to start more or less from the beginning. And I will point out the things that are going to be important for you to know. So, and again, if you have something, stop me. Okay. All right, let me also say this, just in terms of a quick thing on format. You're going to have the whole 50 minutes. If you can get here just a smidge early, that's always a good thing. So we can all start right on time and you have the full 50 minutes. A lot of times people don't even need the full 50 minutes, but in case you do. And it's going to be what I call a short essay exam, which means typically each question might require a paragraph, maybe two at the most. There are probably a couple of them where you can just make a list of a quick 4 or 5 items or something. So that's kind of format. I will have the questions and plenty of paper for you, so you'll be set on that. In terms of the first thing you need to know is really no surprise at all. Those themes about crime and the criminal justice system. And you remember, those are the ones, there were 9 of them that we covered in total. And the first one was the diverse nature of criminal behavior. And the second one was, therefore, it is not likely that there's going to be any single solution to the crime problem, rather a series of incremental changes that may make a difference in crime. Okay, and there are, as you know, 7 others, which I'm not going to bore you with right now, but what I'm likely to do on a question like that, I don't typically, 9 themes is an awful lot. If I were you, I would get pretty familiar with 6, 7 at the most, and that's probably what I'll ask. I'll ask you to identify and briefly explain, 6 of the themes about crime and criminal behavior and criminal justice. So that'll allow you to just kind of list those 1, 2, 3, 4, 5, 6, 7. Yes?
Are you gonna ask us to pick whichever ones,
Yeah, yeah. You don't need to know a particular. Now there will be, and I'm glad you said that, Corinne, because there will be one that you have to answer. Well, what I'll have is 10 questions, and then I'll tell you have to answer, there's one that you have to answer, and then you have to answer 6 of the remaining 9 questions, okay? So it'll be a total of 7 questions. And please, I know this seems like a picayune sort of thing, but please check to make sure that you answer 7 questions. Inevitably, there's always 1 or 2 people that answer 6 questions, or they answer 8 questions, or whatever. 7 total, a mandatory 1, and 6 out of the remaining 9, your pick, okay? All right. Okay. Let's see here. All right, well, that's good. Now, here's a couple of other things you need to know that are related to the themes, but they're not included in the themes. You don't have to tell me about this in the themes. One, and it would be a separate question if I ask it, would be to tell me Robert Bond's crime typology. And the way I'm would ask something like that would be, you list those 7 different kinds of crime in the typology. Remember, that was the one that starts with person-to-person violent, person-to-person property, et cetera, et cetera. And you must give me, in addition to that, an example, a specific kind of crime example. For example, person-to-person violent crime, murder, or person-to-person violent crime, rape, or whatever it might be, okay? Yes, ma'am.
In the list, there was 9 total, but I think the last 2
Yeah, that's
not included. We don't include those.
Here's what we're going to do. There are, yes, I actually gave you 9, but Robert Bond's original crime typology is only made up of the first 7, so that's all I'm going to ask you for, the 7. So in other words, on a question like that, there will be a total of 14 responses that you will have to give, okay? 7 different kinds of crime and an example for each one of those 7. Okay, that's pretty straightforward. And the other thing that is kind of related to those criminal justice things, but I'm going to ask as a separate question, is the criminal justice funnel. And you remember that the criminal justice funnel was simply the documentation that I provided for the notion that the criminal justice system cannot solve the crime problem, which was the 9th of those themes, okay? So I would just, again, I would just ask that as a standalone question, explain the criminal justice law. Okay, good. All right. I do say in that question about the themes, I do say identify and briefly explain. I guess all I would say about that is just be sure that I understand what you're saying. Don't, let's not be using any shorthand, or I want the full theme, and I want to, you need to act as if I don't know a damn thing about it, so that I understand what that means. Okay? All right, very good. Okay, let's move it along. Oh, here's one other thing that and this is kind of borderline related to the themes. We talked about in theme number 7, where we talk about the fact that the criminal justice system is in the business of negotiating what is the crime and who is the criminal, and they do this through a process of interpretation, negotiation, storytelling. One of the things I'm trying to show you in that little scenario, and remember that's the scenario where we do the example of the guy that gets into the garage and so forth. One of the things that demonstrates is a kind of important point, which is the difference between what we call the social construction of crime and what we call the legal construction of crime. So as a standalone question, I might ask, please distinguish the legal and social constructions of crime. Okay. Everybody know that? Feel like you know that? Want me to go over it? Okay, I have a couple of nods of the head. Legal construction of crime. Legal construction of crime says that in explaining crime, criminal justice and the criminal justice system, the legal constructionist only looks at legal factors, okay? Those factors happen to be due process rights, rules of court, and what the actual statutes say, okay? However, most criminologists nowadays, if not all criminologists, think that the crime, criminal justice system, criminal behavior can be better explained by those legal factors, but also by taking into account the social, political, economic, cultural factors. And that approach to explaining crime and criminal behavior is called the social construction of crime. So what the social construction of crime says is, yes, the legal factors are important. Yes, we do have to look at them. Yes, we do have to take them into account. However, they're not the be-all, end-all. If you also were to include the social, economic, political factors, you'd get a better explanation. And now, to kind of top this off, the reason that part of the reason why I gave you that scenario in the garage and all of that is because it was a classic example of what those legal and social factors are. There was an issue of, what does it mean from a legal standpoint in terms of the statute? What does it mean that door was slightly ajar? What does it mean whether he was drunk or he was not drunk? What does it mean with he picked up the tires and he moved the tires a little bit versus all the way out of the garage or, you know, to a waiting car or whatever. Those were all kind of legal issues, okay? We were wondering, does this set of facts suffice to be interpreted in the statute as actual trespassing, or as actual burglary, second degree, or as actual drunken public, or whatever the heck it was, okay? So those are legal issues. But we also looked at the social factors. In explaining what happens in this case in the courts, what the disposition of the case is ultimately going to be, we need to also take into account if this guy is a young teenage white kid from the neighborhood, or he's a 37-year-old adult African-American male from the other side of town. What difference does it make if your attorney is Scott Rosenblum or Heine Minush? Heine Minush is a bad attorney. Scott Rosenblum is a real good attorney. Okay. Charges a lot of money. Heine Minush is much cheaper. Anybody really know who Heine Minush is? He's a ball player. An old ball player. Long ago. Not a lawyer. Okay. So, okay, everybody kind of got that. So in other words, we still want to look at the legal factors in the social construction of crime, but we think we can better explain crime and criminal behavior and case dispositions by looking at legal and those other social, political, economic factors. All right, good. Okay, so, got to keep moving here. All right. Okay, I did already talk about the criminal justice funnel. Let us move on. Okay, brings us to the criminal justice wedding cake. And as you also might not be surprised, that's going to be something you need to know about. And you are going to need to be able to tell me what those 4 different layers are of the cake, which, as we found out, were celebrated cases, serious felonies, lesser felonies, and junk cases. And I want you to be able to give me at least 2 characteristics of each of those different layers of the cake. For example, serious felonies can be described as being violent crimes. They can also be described as being crimes where there is typically harsh or punitive treatment by the criminal justice system for those kinds of offenders. Okay? And the same way with celebrated cases and junk cases and lesser felonies. I want you to know at least 2 characteristics of each of those 4 different kinds of cases. All right, so here, one more example, celebrated cases. Those are cases where the victim or offender are celebrities of one kind or another. You know, sports players, actors, actresses, political people, whatever. And the other kind is what are called precedent-setting cases. That is to say that this case changed the way we do business in the courts. Gideon versus Wainwright, 1963, requires that serious offenders, felony offenders, must be represented in the system by an attorney, and that if person is indigent, they are still going to be entitled to an attorney. Okay, so precedent-setting kinds of cases. Miranda versus Arizona, same way. All right, questions on that? Comments on that? Problems with that? Cool. All right. We move on. You need to know the three factors that determine how we slot cases in the criminal justice system between serious felonies and lesser felonies. Remember those three factors: the seriousness of the crime, prior record of the suspect, and the victim-offender relationship. And you need to kind of understand how that works. Some of those factors are going to allow the criminal justice players to reduce a serious felony to a lesser felony. Sometimes it works in the reverse way, that one or more of those factors allows the case to be moved from a lesser felony to a serious felony sort of status. All right.
That's a separate question outside of the white key.
No, not necessarily.
Okay.
Not necessarily. But I mean, the questions will be very clear as to what you need to put where. Or at least I think they are. All right. Okay, you're also going to need to know the purpose. What is the purpose for the criminal justice players of that criminal justice wedding cake? Anybody want to hazard a guess?
Make things like fair and make sure justice is done.
I really don't think so. Here's what I think. I think that criminal justice wedding cake allows the players in the system to process a huge number of cases in an easy, efficient sort of way, to basically get the job done without having to reinvent the wheel for every case that's out there. You know, if it's a, what would be a good example of that? Like, you're not at home, somebody breaks into the house, grabs a computer out of your living room, and hightails it out of there as soon as they can, because that's what they wanted, was the computer. All other things being equal, unless this guy is like Jack the Ripper or something, that's going to be slotted as a less serious felony with a punishment fitting a less serious felony. You know, we don't have to go back and determine for every one of these burglaries where nobody's home and there's some halfway worthwhile thing stolen. We don't have to determine each and every time whether it's a lesser felony or a serious felony or a junk case. We're gonna, as criminal justice players in the system, we're gonna treat it 99 times out of 100 as a lesser felony. Okay, so it allows for an easy, impersonal, efficient way to process a huge number of cases. All right. We continue to march on. All right, and that's good on that. And that was all material that came out of other sources, not the textbook here. So that's kind of the end of what I had in that other material. Now, keep in mind, you are responsible simply for that material, specifically what I just told you about that material. And you are also responsible solely, really, for Chapter 5. We didn't get as far as I thought we would get. We'll be picking up after the exam with Chapter 4, which is on statistics and that kind of thing, sources of criminal justice data. But the rest of this is going to be Chapter 5, and it is really almost everything that I told you came out of that chapter. So if you have a text, you may want to go to that, or if you don't, you may want to make some notes here. So let me run through this. All right. You need to know the various levels of how the courts are organized. You remember we talked about both at the state and the federal level. Lower level of felony courts is that trial court, where they actually look at and determine what the facts of the case are. They take evidence. That's the only place where you would have a real, quote, trial, although those trials don't happen very often, but that's the only place you'd have a trial, where you'd have witnesses and they'd be testifying, and you might even have expert witnesses, and you'd have perhaps various physical evidence taken into account, and so forth and so on. They deal with the facts of the cases and determine guilt or innocence based on the facts and the judge or jury interpreting what the law is. The next two levels above, the appeals court and what's called the appeals court in most states, we said here in Missouri, it's called the Missouri Court of Appeals. In the federal system, it's called the U.S. Court of Appeals. Whichever, that's that kind of second level. But that second level is not a trial court. It's not a fact-finding court. It only takes into account legal matters, okay? So appeals are strictly matters of law. Due process rights issues primarily, but also it can be rules of court, or it can be statutory interpretation. Okay? Please ask questions if you've got them. All right. So you need to kind of be able to briefly explain those levels of the court systems and what happens and what in general terms happens in at those different levels. Okay, you're going to need to be able to tell me what the criminal law related amendments are of the Bill of Rights. This does not mean that you need to memorize them or be able to write them down on the test. You just need to know in very general terms what they're about. The Fourth Amendment, for example, is largely about search and seizure. Okay? So those criminal law related amendments, and just for a refresher, those would be the Fourth, Fifth, all of the Fourth, part of the Fifth Amendment, all of the Sixth Amendment, and part of the Eighth Amendment, the part that talks about cruel and unusual punishment. here on page 117. You need to understand what the nationalization of the Bill of Rights is all about. Remember, initially, all of the Bill of Rights, including those criminal law-related amendments, were restrictions in the federal system. Restrictions against the federal system, okay? You were getting those rights, all of those rights in the Bill of Rights, including those criminal law-related due process rights. They were available to you in the federal system. That's what they were designed for, okay? The colonists were very leery about a very powerful central government. So those were restrictions on what the federal courts and federal law enforcement can do. They were obviously rights for the people. Okay, so this goes on for almost a couple hundred years till we get to the 1960s. And the liberal, relatively liberal Warren Court and the liberal times of the 1960s leads to some huge changes in the criminal justice system. And the huge change that it leads to is the way that business is done in state courts and at the state level. And most of those criminal law-related amendments that used to be only available in federal courts, through a bunch of decisions that occur in the 1960s in the, quote, criminal law revolution, make most of those rights, criminal law-related rights, available not only in federal courts where they already were available, but now in state courts. So now that right to an attorney in a felony case, even if the person is indigent, becomes available not just in the federal courts, but now in the state courts. And remember, the state courts handle literally 90% of crime and criminal cases. So that's a huge change in the way we do business. That's why that's important. Okay, so in effect then, what I kind of want you to know, and this isn't all of it, but the criminal law related, most of the criminal law related rights in the Bill of Rights are what's called selectively incorporated into the state courts, okay? And remember that selective incorporation is important because there are a few of those individual rights within the Fifth Amendment that never were incorporated into state courts. So it's not all of the criminal due process rights that are incorporated into state courts. It's most of them, okay? And you can see in the text which ones were, which ones weren't. We're not going to get into that much specificity in the test, but you do need to understand that, as they say here, they call it the nationalization of the Bill of Rights. What they mean by that is just now it's available in courts across the country, not just in federal courts, but in all state courts as well. Okay, all right. And then another area, and this is obviously very much related, but you go a couple pages over on 120, and there's, at the bottom of 120, there's a title, The Criminal Law Revolution. And you need to understand what that criminal law revolution is. From 1961 to 1969, through a series of cases, those individual rights, most of those individual rights contained in the criminal law related amendments in individual cases are extended to defendants in state courts, okay? Starts with Mapp versus Ohio in 1961, having to do with searches and seizures, and it goes all the way up to 1969. Yes, ma'am?
Would those cases be considered celebrity cases?
Yes, yes they would. Good point. Yes, they most definitely would. They're celebrated cases, not because there were celebrities there, they're celebrated cases because they were precedent-setting cases. They changed in a very significant way how we do business in the state courts. Excellent, good point. All right. We keep moving in the interest of time here. All right. Next thing I told you about is on 122, 123, and that is the difference between substantive due process and procedural due process. Substantive has to do with the substance of the law itself, what the statute says. Typically, that's not really a problem. That's not something that leads to a lot of appeals of cases. It's the other one, procedural due process, that is typically, probably most often, the grounds for appeals, is appeals on the basis of procedural errors that are made. Things that have to do, for instance, as they say here on page 125 under procedural due process, problems with failure to give notice to defendants of hearings, failure to conduct a particular hearing, failure to allow the defendant to present a defense in his or her behalf, failure to provide an impartial tribunal, failure to provide an atmosphere of fairness and justice. Example of that, search warrant. Police fail to get a search warrant, or in their execution of the search warrant, they go beyond the scope of the search warrant. Search warrant allows them to search for contraband in the alcove of the off the front room on the first floor as you enter the building. And they wind up finding the drugs in a second floor bedroom in the closet. No can do. All right. That would be an example of a violation of procedural due process. Not fair, not just, no can do. Okay. Yeah, here's a real nice little kind of summary of this. Procedural due process is concerned with the notice, hearing, and other procedures that are required before the life, liberty, or property of a person may be taken by the government. Okay? We wind up arresting this guy based on this bad search, and we go ahead and prosecute him, and he's convicted, we're taking his liberty away without due process of the law. Okay. All right, good. All right, I'm moving along here to 127. There's a section on pre-arrest investigation. We talked about what goes into a short-term investigation versus what goes into a long-term investigation. You're going to need to understand that. You're also going to need to understand how police find out about criminal behavior. I think I gave you 4 separate ways that happens. Police observation and use of informants, notice from, or information from witnesses, information from victim, and even in some cases, defendants wind up turning themselves in. All right, I'm not going to go into details on this stuff because it's right here in the book, but you'll need to know definitions of what an arrest is, what an arrest warrant is, what the term probable cause means. I don't think I have anything on booking. I wouldn't worry about that. I don't think I have anything on initial appearance. Wouldn't worry about that. Do have something on preliminary hearing. That's an important hearing. And what you're going to need to know is at least 3 or 4 of those things that the judge looks at the preliminary hearing. In fact, they have a list in here. This preliminary hearing is supposed to be protection against improper, unfair treatment by the criminal justice system against a defendant. So we're really trying to protect the defendant's rights. So what the judge needs to look at, for instance, is determining whether at that hearing, whether or not even a crime has been committed. You know, not even worrying about did she do it, but has there been any crime committed? He's got to make that determination. Then if he makes that determination, he's got to make the determination whether there is probable cause, that is to say, sufficient evidence, reasonable likelihood that she did that particular crime at that particular time and place. We've also got to determine, the judge has to determine, whether there's probable cause for the warrant for arrest at the time it was issued, or whether there's probable cause at the time the officer did the arrest if there was no arrest warrant used, if it was arrest without a warrant. And finally, we've got to figure out if there was probable cause for the search warrant, and whether or not the officers abided by the law in the conduct of the actual search itself. All right. Oh, okay. All right, we're getting close. You need to know about the 2 ways that charges can be formalized. That is through, the typical way is through the prosecutor making up an information in which he alleges the charges, which is tested at a prelim. The other way is through a grand jury. Okay, let's see if there's anything else here. Oh, you need to know what a pre-sentence investigation is and just briefly what is contained in it. Hang on one second, see if there's anything else here. Well, I'll tell you what, you know all that, you're going to be flying high.